Is it ethical to let somebody sit on life support for 15 years? My name is Amanda Rocha. I am an estate planning and probate attorney in California, and whether or not that's ethical is not my business. What is my business is what legally you can do to prevent yourself or a family member from being in that situation. If you were around during the 90s, you may recall the Terri Schaivo case from Florida, where a young woman had a medical incident where she became in a persistent vegetative state. And because of the disagreement between her husband and her parents and the lack of documents on her behalf, she was left in that persistent vegetative state for 15 years before she was allowed to peacefully pass away. So what can you do and what could she have done to prevent that? In California, we have something called an advanced healthcare directive. It's a document where you list what your medical wishes are if you cannot say so yourself, and you also are nominating a person to be your healthcare power of attorney, your agent, to act on your behalf if you can't say so. They'll follow whatever you put in the living will. That's the portion where you say your medical wishes, and then anything above and beyond, they will make the best decision for you at the time. Without that, a judge gets to decide who is best suited to make those decisions for you. And if you did not have any conversations with that person ahead of time, then they may not know what you have wanted. It is also much more cost effective to create one of these documents on your own instead of having your family members go through a legal process to get assigned that power themselves. If you have questions, drop them below.